Through the years, I've seen mental health in the criminal justice system gain a greater understanding, acceptance, and involvement in the resolution of criminal cases than in years past. I, quite frankly, attribute a lot of that to the Andrea Yates case, where an insanity defense was initially rejected and then accepted by a jury, and she was found not guilty by reason of insanity. That caused a great stir, if you will, within the public's perception of mental illness in the criminal justice system. It has brought an emphasis on mental illness, even if the individual who is mentally ill is not in the criminal justice system. But I have seen that take place. I've also seen the roles of psychiatrists, psychologists gain steam within the criminal justice system, if you will. And I would advise, if you've got a client, and I'm speaking to attorneys now, if you've got a client that evidences any type of mental illness, disorganized thought process, laughter that is not appropriate, delusions, for instance, people with mental health histories, maybe the individual has been in and out of a mental health hospital, or maybe the individual should have been in a mental health institution, but the family did not have the necessary resources to attain not only the services of a psychiatrist, but also to place the person into a mental health hospital. It behooves all of us to go back to even day one and find out how that person reacted. For instance, in Andrea's case, we went back to grade school days to see what, if anything, developed during the course of her graduation on the way up, and we found some things that were keys to a foundation whereby we were able to build from a criminal standpoint, or criminal defense standpoint, and a credible insanity defense. The standard, unfortunately, in insanity in the state of Texas sounds very simple, but it's very complicated. The standard simply says that an individual must be suffering from a severe mental disease and or defect, but that's not enough. That mental disease and or defect has to result in that person not knowing what that person is doing is wrong. There's no definition of the word no that goes to a jury. There's no definition of the word wrong that goes to a jury. So we can have experts on the witness stand that can impose his or her own opinion of what no means to a jury, and have an individual who is extremely sick sitting in front of that jury being judged by the objective, non-mental health interpretation of what the word no means by an expert, and that happens. I'm in favor of there being some type of definition that goes to a state jury as far as the word no is concerned and the word wrong is concerned. But again, getting back to the basics, there are a number of experts in our area, and lawyers should take advantage of those experts, either by way of competency evaluation or sanity evaluation if the individual shows any sign of not being able to understand what's going on, not be able to effectively help the attorney represent him or her, or if there is something that is obviously very insane about the act the individual is accused of doing. Most of the time, when the insanity defense is used, it will be involving a case that is so bizarre that there's no rational motive for the individual to do what he or she did. I have a client who, without provocation at all, no argument, decided to decapitate his co-worker, and did. And obviously the insanity defense, we have a history of prior mental health problems, is going to rise to the fore in that case.